Law 529 Hearsay, Section 32. In our previous lectures, which is in the introduction and concept lectures, we have discussed about one of the most important canons in the law of evidence, that is hearsay evidence. Alright, we also have discussed in our previous lecture some of the exceptions to the hearsay rule, which we have discovered with, in particular the one under Section 6 under res gestae hearsay principles, where the evidence, for it to be an exception to the hearsay rule, it has to be spontaneous, contemporaneous, and the mind of the maker has to be dominated by the event so as to eliminate any possibility of fabrication. That will be the first exception which we have studied. The second exception to the hearsay rule which we have studied so far is the one provided for under Section 17 to Section 31 of the Evidence Act, which relates to admission and confession. So in this lecture, we are going to look at another exception to the hearsay rule, which is the one covered by Section 32 of the Evidence Act. Now, what is hearsay evidence? Okay, hearsay evidence can exist in two forms. It can exist in an oral form. It can also be in a documentary form, right? In oral form, when a witness gives evidence in the court, but the evidence of fact is obtained from a third party. This is a situation where you have a third party who perceived the incident, told it to the witness, and the witness is the one testifying in the court. The evidence of the witness here will be hearsay evidence. Another form of evidence is when a document is produced. You have a third party here who perceived the incident and then reduced his particular statement in a written document form. This document is the one that is tendered as evidence in the court to show the truth of the content of the statement. The maker of the document, which is the third party, was not called to verify the content. So the document here, if it is produced, it will be a hearsay evidence, despite it being primary or original document. So basically what you have here, right? So you have here a hearsay evidence, right? So hearsay evidence can be where you have a third party here perceived what happened, inform it to the witness, and the witness is testifying in the court, right? This is hearsay evidence which is in oral form. It can also be hearsay evidence when you have a third party here write in a document, and this document is the one that is produced in the court. So there's no one to verify the content of the document. Okay? Now when we talk about hearsay evidence, alright, let's look at the notes here. As a general rule, hearsay evidence is not relevant and it is inadmissible. Right? Why it is not relevant or admissible? The general rule is actually provided for by the case of Subramaniam, where in the general rule, it is not relevant or admissible. Right? So what happened here is that the rationale of the general rule is that this particular evidence is not the best evidence to be tendered in court because it was not taken on oath. Right? And there is a possibility of this kind of evidence when it is tendered in the court, it will be subject to concoction and fabrication. Now, this is a situation where you have one person giving it to another person, the possibility of it being fabricated and concocted being very high, right? And another reason why it is regarded to be highly prejudicial because of the inability of it to be verified, and as a result, the untested evidence becomes used and it is going to be highly prejudicial. Remember, what happened in this situation here is that you are calling the witness here to testify in the court. The witness here cannot give sufficient response when he is examined in chief, cross, and re-examination. So because of that, the evidence here cannot be determined as to the truth of the content of it. So because of this, it's going to be highly prejudicial. So the property value is going to be lower, then prejudicial effect is going to be higher. Right? Okay. And having said that, now if you look at the case of Subramaniam, okay, of course this case provided you with a general rule that hearsay evidence is not relevant and is not admissible due to the prejudicial nature of the statement. However, this case indicate to you that when you are considering hearsay evidence, you have to be very careful, because there will be some instances where the situation looks like a hearsay evidence, but it is not actually hearsay evidence. Now, what happened in Subramaniam? Yeah, in Subramaniam, the court says that, so you have Subramaniam here, an evidence is regarded to be hearsay evidence if the object of the evidence is to establish the truth as to what contained in the statement. So you have here the object is to establish the truth with regards to the content of the statement. So it means that you have a third party here giving evidence to the witness testifying in the court. What is said by the witness here is regarded to be the truth. So you want to rely on the witness statement here, repeating what the third party was saying to be the truth, when the witness here did not actually see what happened. You have an illustration where, example that I always give you, that is, you have Ali kill Mona, right? And Zack went to Mona, and while Mona was in dying breath, Mona said to Zack, Ali did, right? And in this situation, Zack will be the one repeating what Mona said in the court upon death of Mona. Right? You want to rely on the statement made by Mona, repeated by Zack here, so to say that Ali did, whereas in reality Zack did not actually see Ali do the act of stabbing, right? Because Zack did not see Ali do the act of stabbing, you are going to rely on whatever Zack say here, repeating what Mona said to be the truth, right? Because of this is hearsay evidence, because your aim is actually to rely on the content of statement to be truth, right? Now, another aspect of statement that has been looked through by Subramaniam is where it is not actually hearsay evidence. The statement seems to look like a hearsay evidence, but it is not a hearsay evidence. Therefore, if it is not a hearsay evidence, it will be relevant and admissible. This is when you have a situation where the object of the statement, when it is tendered, is not to establish the truth as to the content, but instead is to reflect that the statement was actually made, maybe to reflect the existence of some kind of mental state, or to reflect the existence of conduct, right? To reflect the existence of conduct. Now, how will this show? Say, for example, you have here issues with regards to whether A here is insane or sane. Because you have an incident, say, for example, what happened here is that you need to make a decision whether to send A here to a mental health center. So that will be your issue. Now, the evidence relating to A's mental state will become relevant. Katakanlah you hear A talking to himself. He was talking to himself. He says that, I am Siti Nurhaliza. Let's hear me singing the song of Siti Nurhaliza. So what he did was that, after making that statement, he sang katakanlah lagu Anggapanmu, which is actually one of the song of Siti Nurhaliza. And then after singing that, as if he has an audience, he was saying that I am Siti Nurhaliza. Now, it was heard by a witness. So the issue here is when the witness here testified in the court with regards to what A was saying. Now, what A was saying here, according to the witness, is that she is Siti Nurhaliza. The aim of this particular witness here is not to indicate the truth, not to believe the truth as to the content of the statement. Yeah, it is not the aim of the witness here to believe that she is Siti Nurhaliza. But the aim of the witness here is to determine whether he is sane or insane. Yeah? So you see a person pakai baju compang-camping, claiming to be Siti Nurhaliza, I am Siti Nurhaliza. What do you think? Do you think he is Siti Nurhaliza or not? So that is the issue, right? So that's why according to the case of Subramaniam, if the aim of your statement is not to establish the truth of the content but to refer to the mental state or to reflect the existence of conduct, then the evidence here is not hearsay. What was A giving here is what he perceived. So it's actually direct evidence under section 60. A will testify in the court the fact that I heard A singing lagu Siti Nurhaliza and I heard him saying that he is Siti Nurhaliza, but I believe that he is not sane. So the kind of evidence that he gave is actually the evidence under section 60, the one that he perceives. Yeah, in fact, when you talk about the relevancy of this particular statement, it may fall under section 7, that is state of thing. Yeah, so in that situation, this is not hearsay, right? So in this sense, you have to be very careful when you look at a particular statement. You have to determine whether you are looking at the content or whether you are looking at otherwise. Now, having said that, if you are to tender this kind of evidence, remember at the end of the day, how does it relate to the facts in issue? So if the facts in issue is concerned with the mental capacity of the accused person, so the mental capacity of the maker of the statement, then it may be relevant to with regards to the second part of what Subramaniam was saying. Okay? Again, yeah? So as we thought evidence of hearsay is actually not relevant, not admissible. What happened if it was wrongly admitted or not objected when it was offered? Say, for example, you have a hearsay evidence. So you basically have this kind of statement, right? You have this kind of statement, the one that fall under this category, right? It is tendered as evidence in the court, and the court, being ignorant of the law, accepted the statement. So you have the court here accepted the evidence, right? He accepted the evidence, use it, evaluate it, and come to a decision. And you have also an equally ignorant defense lawyer or solicitors where did not object to the tendering of that particular hearsay evidence. Now, what will happen if you have this kind of situation? Okay, according to the case of MNI and Malaysia Rubber Development Corporation, an evidence which is inadmissible will remain inadmissible even though there is no one objected to it. So it means that because this one is failure to comply with Section 5 of the Evidence Act. Yeah, it fails to, Section 5 in the sense that the property value will remain low, prejudicial effect will remain high, right? So it is not, if it is not relevant, not admissible, it cannot be relevant and admissible due to ignorance of a person. So have that in mind, yeah? Now, having said that, so the aim of our today's discussion is actually to look at Section 32. Section 32 is one of the exceptions to the hearsay rule. Now, let's look at Section 32. Now, if you read Section 32, Section 32 cases in which statement of relevant facts by person who is dead or cannot be found, etc. is relevant. Subsection 1 to Section 32, statement, written or verbal, of relevant facts made by a person who is dead or who cannot be found or who has become incapable of giving evidence or whose attendance cannot be procured without an amount of delay or expenses, which under the circumstances of the case appears to the court unreasonable, are themselves relevant facts in the following cases. You have A to J. Yeah, the facts in A to J will be the instances where the four categories of person made statement and now cannot verify it in the court. Now, if you read Section 32, basically what you have will be two parts. Yeah, there are two parts of Section 32. The first part is actually explaining who are the persons that can make the statement but now being absent in the court. So you're talking about the who, yeah, who are persons who has made a statement heard by someone else or the statement being recorded but he cannot verify the statement in the court, Therefore, someone else or a document has to be produced in the court in his absence. Now, Section 32 reflects only 4 categories of person that can make the statement, and their absence is tolerated under Section 32 sub 1. Remember, according to the case of Lee Jin Ho and the case of PP against Nur Faisal number 2, there is a need for the party relying on Section 32 subsection 1 exception to prove the non-availability of the maker before exception can be relied on. Right? So there must be strict proof. Yeah? Strict proof as to the non-availability of the maker here, if you want to rely the exception to the hearsay rule. Now, who are the third parties under Section 32? The first one is that it is the person who is dead. Right? You look at the notes here. The first category of person is the person who is dead. Number 2 is the person who cannot be found. Number 3, the person who is incapable of giving evidence. And number 4 will be a person whose attendance cannot be procured without unreasonable amount of delay and expenses. So only these 4 categories of person can be, their statement can be taken as an exception to the hearsay rule under Section 32 subsection 1. So if a person refused to testify for the reasons of refusing to testify, then it does not fall under one of the 4 categories of person. Yeah, even a person who is outside jurisdiction, so if you read the books there, in particular in chapter 5 on hearsay evidence, if a person is being outside jurisdiction, that is also not one of the 4 categories of person. Say for example, you have the maker of this particular statement has gone to katakanlah Sweden or Australia and now refused to come and testify. So if you have that kind of situation, then perhaps, it will not going to fall under one of the 4 categories of person. Okay? So you have to basically prove that he falls under one of the 4 categories of person. Then only, if you look at the notes here, the 4 categories of person make the statement must relate to the 10 categories of facts. So basically you have subsection A, B, C, D until J. And in our discussion in the lecture, we only will discuss 4, that is A, B, I, and J. And the rest you read on your own. Okay, now let's look at the first part of section 32 of the Evidence Act. So you have to prove, the maker of this particular statement, the who question, right? The who question. So who made the statement? You got to prove that he falls under one of the 4 categories of person. Now, how do you prove a person to be dead? You have to prove that a person to be dead. Here, you can prove a person to be dead by production of death certificate. Right? If you have death certificate, katakanlah from Jabatan Pendaftaran Negara. So remember, there's certain law that you have to comply with. This is public document, section 74. Basically, you are referring to this as computer printout. You have section 61, 62, computer printout. Is a documentary evidence, section 3. So certain law has to be complied with if you are to produce that certificate in court. Okay. Number 2, the second situation in which you can prove that the person is dead is actually by production of an oral evidence. So what you have to do is you call the prosecution witness or a witness to testify that the person is actually dead. Right? How will this be done? You have example in the case of Muniandi, where you have katakanlah Ali kill Mona. Mona's dead body will need to be sent to a post-mortem. The doctor who conduct the post-mortem will testify in the court as to the fact that Mona is dead. So it is proven by an oral evidence. You can also have a situation where you have an oral evidence given by maybe your superior, right? So you have your superior here giving evidence that you are dead. You have this in the case of PP against Leong Hyo Cheong. Yeah. So remember, you have to prove that the person is actually dead for it to be for his or her statement to be taken an exception to the hearsay rule. Now, number 2, you have a situation where a person cannot be found. Now, a person cannot be found. For you to rely on a situation that the third party who made a statement here cannot be found, you have to provide proof of attempt that search has been made to locate this person. So, you have to produce proof that search has been made, right? There must be evidence of reasonable search. Yeah, there must be evidence of reasonable search. To illustrate this point, what happened here is that we have the case of Lee Jun-ho. Now, what happened in the case of Lee Jun-ho is that you have here an offense of murder, so it is under section 302 of the Penal Code. You have 2 witnesses. These 2 witnesses are from India, they are Indian descendants. So these 2 witnesses here, statement has been taken from them under section 112 of the CPC. If you look at Criminal Procedure Code, section 112 of the CPC refer to the police officer recording the statement of witnesses, right? So these 2 witnesses' statement has been recorded under section 112 of the Evidence Act. What happened here is that the trial has begun in 2006, but the prosecutor or the police did not attempt to make any search as to the whereabouts of these 2 witnesses. So what happened here is that in 2008 only, right, they start looking for the witnesses, and of course, yeah, because the trial has stretched in more than 2 years. In 2008, they looked for the witnesses, but they cannot find it. Now, in this case, the court says that the prosecutor and the IO failed to prove evidence of reasonable search to look for the witnesses. Yeah, this is actually will not going to be tolerated. And what happened here is that the court expressed that in this situation, you really have to bring the evidence in the court due to the nature of the offense. Remember, the offense here is actually murder, and this person is subject to capital punishment. Because of that, there is more need for you to basically try your best to bring the statement, because otherwise you are subjecting him to very harsh punishment, in the absence of that particular person testifying in the court, right? So you have quite a number of other cases that reflect attempt that has been made but was rejected by the court due to insufficient diligent search. Yeah, so you have that in the case of Morgan Ayavo. You have also in the case of Nur Faisal. You have these examples in the textbooks. There's also one more case that reflect otherwise. You have the case of Gan Kwang. Now in Gan Kwang, what happened was that, the witness here has been attempted to be looked for by the police. So what happened here is that the police has standard evidence of their search in the sense that, they have been looking for the witnesses both in West Malaysia and East Malaysia. So he has been in contact with various departments of police, and then he has put advertisement in various newspapers for several months. Go to the location in which they believe that the witnesses were there, and at the end of the day, the court was very impressed with the attempt made by the police to look for the witnesses. And in the case of Gan Kwang, because of the sufficient evidence of diligent search, the document or the statement made by the witness, who is not called to give evidence in the court, is relevant and admissible under exception to the hearsay rule. Okay, so you have to prove evidence of diligent search. Right, the third category of person is that the person must be incapable of giving evidence. Now, when you talk about a person incapable of giving evidence here, it can either as a result of being extremely old, you waited for your case for so long, so you become extremely old, right? So your competency is now being questioned. And the other one was because of mental incapacity. You become so old, so you become senile. So one is extremely old and the other one your mental capacity, right? Okay, so you become extremely ataupun mental incapacity or You're waiting for the trial, you had an accident, you turn into a coma, so you become incapable of giving evidence. Now, in this context, there is not necessary for you to bring medical evidence to prove that you become incapable of giving evidence. The carer of that particular person can testify as well in the court to show that you are incapable of giving evidence. You have this in the case of Chen Chao Singh. Now, the last category of person that is allowed, whose statement is allowed to be tendered as evidence in the court is where you have a situation where attendance of the persons cannot be procured without unreasonable amount of delay and expenses. Well, remember, you have the word here, reasonable amount of delay and expenses. It means that it is a question of fact to see whether it is reasonable or not. The court will look at the facts of your case to see whether it is reasonable or not for you to produce his document in his absence. I give you an example. So you have here a situation where attendance cannot be procured without unreasonable amount of delay and expenses. Okay, say for example, you have a situation. Okay, Ali was driving his car. He knocked Baka. He knocked Baka down. Right? So imagine that. Okay, Ali is actually an expert in HKL. Right? Baka was sent to him. Right? He undergo operation. Okay. Silap ya sekejap. So Ali is driving the car, was knocked down by Baka. So Baka has been sent to HKL where he was attended to by Dr. K. So Dr. K did the operation, and as a result, now Baka is suing Ali for negligence. Right? Now Dr. K here, went for an exhibition in Arctic. The matter almost go for trial. Of course, Dr. K, when he did the operation, after that he made a report, the medical report of the condition of Baka. So Dr. K now went for an expedition. There was a storm in the expedition where he is actually separated from the team. So now he is missing in action. The matters now go for trial. So Ali, of course, want to call Dr. K to give evidence in the court because Dr. K is the one who do the post-mortem on Baka. The one who do the operation on Baka. So the evidence, kalau you produce a medical report, is going to be hearsay evidence if you want to rely on the content of this particular document. So now, he has gone missing. Right? So Baka is now very reliant on Dr. K because he is Baka's witness. So Baka is the plaintiff here. Right? Now, the lawyers for Baka want to produce the medical report prepared by Dr. K. Okay, and there has been an attempt maybe to look at it under section 299 of the CPC, but it was rejected. So Ali rejected it, so you have to produce Baka has to produce Dr. K as evidence in the court, but unfortunately, Dr. K now has gone into an expedition and is now missing in action. Katakanlah Baka is a very prominent consultant, and as a result, the claim of Baka punya case is actually for RM 2 million. He's claiming 2 million for the injury he suffered. Now, Dr. K now has gone for an expedition. He is missing. If you want to call Dr. K here, does it cost time? You don't know where he's missing. Right, the storming is very bad dekat Arctic too. Right, there have been delay of 3 months. Are you going to accord him more delay? Alright, that will be one issue that you have to consider. And number 2, the cost. Katakanlah cost to look for Dr. K is 1 million. Now, will it be reasonable for you to spend the money 1 million to look for Dr. K when your claim is RM 2 million? So the court has to consider this situation, and what happened here is that right? If your claim is 2 million, it may not be reasonable for you to spend 1 million to look for him. So it may fall under the category of person who attendance cannot be procured because of unreasonable delay and expenses. We are talking about expenses here. Kalau you nak cost, you want to use 1 million. Now, katakanlah you have a situation that Ali killed Mona. Mona's body was sent to Dr. K for post-mortem. Dr. K has gone for an expedition at Arctic, and he is now gone missing. Yeah, he has gone missing. Alright, instead of going to Arctic. Alright, Dr. K now has moved back to his hometown, which is in katakanlah Nebraska. So the cost for you to bring him in to stay here is actually 1 million. Yeah, for him to give evidence in the court. Of course, you do the post-mortem report, right? You do the post-mortem report. You do the post-mortem report, and you want to produce this particular report because now Dr. K has gone back to Nebraska. All right? Now, remember, he is outside jurisdiction, but whether his evidence here falls under attendance can be procured without unreasonable delay or expenses. The cost to bring him in is actually 1 million. Yeah, the cost to bring him in is actually 1 million. This is a criminal case. Now, do you think the prosecutor must spend 1 million to bring Dr. K back to Malaysia and testify against Mona? Right, will it be reasonable or not? 1 million expenses. If you look at the case that we have discussed previously, it is unreasonable because your claim is actually 2 million. Now, how about criminal case? You got to prove actus reus and mens rea. And the outcome of this could be that Ali will be put to jail. So you are talking about Article 5 here. So his personal liberty is being contained because if he is proven guilty. Now, in this context, spending 1 million here is not unreasonable. Yeah, it is regarded as reasonable. Yes, in this case, the government has to spend this 1 million to bring Dr. K back to Malaysia and be cross-examined by the prosecutor. So you got that. So this is where you see the distinction, the issue of unreasonableness to determine whether it is reasonable or not. It depends on the facts of your case. Right? Right, this determination of reasonableness, you have this in the case of Allied Band against Yao Yok Hua. Right, that will be the situation. Okay. Okay, having said that, what we have discussed so far will be basically the first part of section 32, where you have to establish that the person who made the statement fall under one of the 4 categories of person. Now, let's look at the second part of section 32. Now, the 4 categories of person just now, when he is to testify in the court, right, you have basically under section 32, you have the 4 categories of person. Sorry, section 32. Under 4 categories of person, this person must be giving evidence that relates to 10 categories of fact, which is under section 32 sub 1 sub A, B, C, D until J. Right, so maknanya if he is giving evidence that does not fall under one of the 10 categories of fact, their evidence will be rejected because it failed the condition of facts under the second part of section 32. Yeah? Now, the first one that we are going to discuss here will be section 32 sub 1 sub A. We have been discussing this one for quite a number of times now. Let's look at 32 sub 1 sub A. When the statement is made by a person as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death, in cases in which the cause of that person's death come into question. Now that part here referred to, you have a third party here who made a statement, and the facts in issue here is who killed that person. This is exactly the situation where you have, right? You have Ali kill Mona. Mona gives statement to Zack before she's dead, and Mona said to Zack, Ali dead. So you have a situation here. Mona now dies. Zack become your prosecution witness. Zack here is giving evidence relates to Mona's cause of death. Yeah. Now remember, under section 32, there are two kinds of statement that could possibly be made by the third party here. Number one, the statement is made relating to the cause of death. So the statement must relate to the cause of death. And secondly, the statement relates to the circumstances of transaction which resulted to death. So this is the second part of your of the statement mentioned under section 32 sub 1 sub A. Alright, look at 32 sub 1 sub A again. Such statement is relevant whether the person who made it was or was not at the time when it was made under expectation of death. So in this situation, Mona here, it is not necessary for you to show that Mona actually expect to die or not. Maknanya expectation of death here is not mandatory if you are relying on section 32 sub 1 sub A. This is very unlike the position of common law. Alright. Now cause of death will be like, so I'm giving evidence, Mona is giving evidence to Zack, Ali did. So you are talking about here, Mona is talking about the cause of her death. Right? Okay, this is actually the part where we say about dying declaration. This is exactly dying declaration because the statement was relating to the cause of your death. Okay, this one, the second one, the cause circumstance of transaction which leads to death. This is not exactly dying declaration. It allows for a degree of lapse of time. Okay? Right? This one, okay, you have to look at the case of Yeo Hock Seng to understand what does it mean by circumstances of transaction which resulted in death. So you have the case of Yeo Hock Seng. Right? Now, and also you got to refer to the case of Pakala Narayana Swami. So you have the case of Swami against against E, an Indian case, yeah? Swami against E. So what happened here is that circumstances of transaction which leads to her death must not be the nature of indicating general expression of fear or suspicion. It must not be of general expression of fear. The statement must have some proximate relation to the actual cause of death. Now, what happened in the case of Yeo Hock Seng is that, right, in Yeo Hock Seng, is a situation where, sekejap, in Yeo Hock Seng, you have here the victim made a first statement to the father 1 month or 2 months before she died. And she said to the father, I was forced to go and sleep with the accused person. Right? And the court says that because the statement was too long, there have been an intervention. Therefore, the statement is too remote, not relevant, not admissible. But the second statement that the court wants to consider is the one that the victim made to the sister. She made the statement to the sister the night before she was murdered, where she told the sister of the fact that my fiancé, the accused person here, wants me to go out with him tomorrow and I have to disguise myself in men's clothes. So this is a statement that V made to the sister the night before she was murdered, and her body was found hanging on the cliff wearing men's clothes. So in this case, the sister will become your prosecution witness, repeating what V was saying, and the statement here is reflecting of the circumstances of transaction which leads to her death, the fact that she was asked to disguise herself in men's clothes, right? That is the position of circumstance of transaction which leads to the death. Okay? Now you see, there is a certain lapse of time allowed when you talk about this second category of statement under section 32 sub 1 sub A. It's different from the cause of death. Yeah? When you talk about the cause of death, statement here is more specific. It relates to the cause of death, and you have quite a number of illustrations to reflect cause of death. You have this in the case of Hashim bin Arifin, right? You have the case of Saraman or Jayaraman, where you have a statement. In the case of Suraman, you have the statement made by the victim as to who caused the fire on her. So this is a situation where the wife here was burned to death. So the wife here has been, the husband came home, right, was very angry and drunk, took some petrol, put it on her and lit fire on her. So she was basically making the statement as to who lit fire on her to the doctor and to the ambulance attendants prior to her death. That statement relates to the circumstance of transaction which leads to her death. Now, when you talk about statement under cause of death here, you got to see, when the victim here made a dying declaration, right? The victim must make the statement in a fit state of mind. The mind is still sane when he made the statement, and he was making the statement in that context voluntarily and truthful. So you have a situation where in the case of Suraman, you have basically the wife here has been put some petrol by the husband and lit fire, and the fire was lit on her. Okay, she was basically maybe 70% burned. She was brought in an ambulance to the hospital, and while she was in an ambulance, she made a statement that the husband was the one who lit fire on her. She made a statement in a situation of fit state of mind, and the statement was made voluntarily, and the court basically accepted that kind of statement as statement under dying declaration in section 32 sub 1 sub A. Got that? So that will be the first facts referred to under section 32, which is section 32 sub 1 sub A. You have to understand the statement made by the maker must relate to the cause of death or circumstances of transaction which leads to her death. Now, the second category of statement, of facts referred to under section 32 will be under section 32 sub 1 sub B. What is 32 sub 1 sub B? When the statement was made by any such person in the ordinary course of business. So you have the keyword here, ordinary course of business. And in particular, when it consists of entry or memorandum made by him in books kept in the ordinary course of business or in the discharge of his professional duty. So it is a statement made in the ordinary course of business or in the discharge of professional duty. So this is the keyword that you have to bear in mind, right? So this particular statement can be tendered as evidence in the court. Remember, when you talk about ordinary course of business here, it is not necessarily be commercial statement, right? Right? It is not necessarily commercial statement, but it has to be statement that is taken in the course of his ordinary business, where the maker here must have personal knowledge of the matter. Yeah? The maker here must have personal knowledge of the matter. Say, for example, I give you an example. You have here, katakanlah, the issue here is whether A, took the check, took the company's check. So you have here maybe CBT, criminal breach of trust. The evidence here is that A has been using the company's check. Company's check. So what happened here is that you have an account clerk. The account clerk will be the one that is going to register the in and out of money and check from the company. So what will happen here? You have an account clerk and account book. So the account book will register the money in, or the check in and the check out, right? So what happened here is that he will be keeping record of company's check which is issued in the name of A personally. Now, this particular person is dead. The account clerk is dead. What happened here is that you want to produce the account book that is kept by the account clerk. By right, you have to call this account clerk to give direct evidence in the court. Now, what happened here is that since he is fall under one of the four categories of person, you want to bring in the account book kept by him in the ordinary course of his business or in the discharge of his duty. Now, this particular account book can be tendered as evidence under section 32 sub 1 sub B because this particular account book is kept in the ordinary course of his business. Yeah? This is where you have it in the case of Lee Chi Kyong, right? Simple as that. Now, the second two category of facts which we are going to discuss will be under section 32, sub 1, sub I, and J. Now, section 32, sub 1, sub I. What is 32, sub 1, sub I? When the statement was made in the course of or for the purpose of an investigation or inquiry into an offence. So, 32, sub 1, sub I, referring to a statement made in the course and for the purpose of investigation into a criminal offence. This is the first one. The second one, J, here you are talking about the statement was made by public official in the discharge of his duty. Yeah, in the discharge of his duties. Right. Now, statement in the course of investigation. I give you an example. Remember, yeah, section 32, sub 1, sub I and sub J here must be read disjunctively in the sense that you read it separately. It can stand alone on its own. Right? I give you an example of this kind of statement. Statement in the course of investigation. Say, you have, katakanlah, A is a trafficker. He is being subject to observation by police. So A here is caught while he was trying to sell the drug to B. So B is maybe a drug user. A is a drug trafficker. So both of them were brought to the police station. Both of them were interrogated separately. B were interviewed as a witness under section 112 of the CPC. Right? So he is actually accepted as a witness. So his statement was recorded under section 112 of the CPC. When I say a statement is recorded, it means that it is put in a writing in a documentary form. It is recorded in a statement under 112. Now what happened here is that, katakanlah the matter goes for trial, B falls under one of the four categories of person, cannot be found, ke date, ke whatever. You want to produce the document made by B as an evidence in the court. So this will fall under section 32, sub 1. Section 32, sub 1, sub I. Section 32, sub 1, sub I, because this is a statement made, yeah, during investigation. So this is a statement made during investigation. You got that? Because you are talking about investigation into A's criminal liability of trafficking drug. Okay, you have this in so many cases. You have in the previous one, we have the case of Chang Kao Meng just now. We have the case of Lee Jun Ho that reflect this kind of situation. Alright, see? Okay, now what is in illustration? What is 32 sub 1 sub J? 32 sub 1 sub J here is reflecting on statement made by public official in the course of his duty. Say for example you have katakanlah the IO conduct investigation, what he do is write down in his diary. So the IO, when he do investigation, he has investigation diary. So this will be the diary that he officially kept and record whatever that transpired during investigation. Now, he is now dead. You want to produce this diary in the court. So this will be an example of section 32 sub 1 sub J. Right? Or you may have a situation where you have the doctor who conduct post-mortem. Yeah, you conduct post-mortem. You have the report, post-mortem report. The post-mortem report also falls under exception to the hearsay rule. Yeah, if you want to tender it. But remember, yeah, this one, the best is actually for you to bring the witness in the court. Because even though it may be in performance of its official duties, that's why it becomes hearsay. You got to really ask for it to fall in exception to the hearsay rule if you want to rely on this. Now, bear in mind, you have one provision in the CPC that you have to bear in mind. That is section 299. Yeah, 299 of the CPC. where Section 299 of the CPC basically says that, right? Section 299 of the CPC basically says that if you have documents produced by certain individuals, yeah, of the government official, like the medical doctor here, you can rely on the document made by him if the prosecutor produced a letter 10 days before trial to say his intention to rely on the document without calling the maker. Then the document can be tendered without the need to call the maker. That will be Section 299 of the CPC. However, if the document is tendered by the prosecutor to the accused person in 10 days, but the accused person or the lawyer reply within 3 days to require presence of that particular medical officer, then Section 299 says that you have to call the maker of that particular document. That will be under Section 299 of the CPC. Yeah? Right, so now when you have this, maknanya if you look at Section 32 sub 1 sub I, here you are talking about 32 sub 1 sub I, you are talking about it in the context of the witnesses making the statement. But when you talk about 32 sub 1 sub J, you are talking about in the context of the public official recording the statement. Yeah, so you have that. Yeah, so both of it can be read disjunctively. Now, there have been there have been discussion as to whether Section 32 sub 1 sub I and J should be read disjunctively or conjunctively, maknanya read separately or together. You have that approaches which has been illustrated in 2 cases. Basically, you have the case of Sim K Che, and you have the case of Lam Peng Hua. Right? Lam Peng Hua basically suggested that it has to be read disjunctively. Maknanya you tak boleh baca dua-dua sekaligus. So you have to read it disjunctively. Right? Maknanya that disjunctively means that it can stand alone. But the case of Sim K Che, right? They were suggesting that it has to be read together. Right? Now what is the implication? Now, if it is to be read together, then it becomes very strict. Then, maknanya if you have, because this is to overcome some issues on double hearsay. Yeah, on double hearsay. So, I will discuss what does it mean by double hearsay when I see you in the face-to-face discussion. Okay? Now, having said this one, so basically what we have covered so far will be exception to the hearsay rule under Section 32. We have understood of the fact that hearsay evidence under 32 are the 2 parts. The first part talk about the 4 categories of person, and the second part of talking about the 10 categories of fact that may be considered under Section 32 sub 1 sub A. Now what will happen here is that if an evidence here is hearsay, right, and it is taken in as an exception to the hearsay rule under Section 32, it now becomes relevant and admissible. Remember, the weight is a different issue. There can be a situation where it is taken in as evidence in court, relevant and admissible, but the weight can be given by the court 0 weight, because it is actually the authority of the court to determine how much weight it can put on a hearsay evidence. So, but the aim of the prosecutor or the aim of the parties is actually try their best to bring the hearsay evidence as an exception to the hearsay rule, because issues of weight is basically beyond their power. Right, on this note, we basically has completed our discussion on hearsay evidence, and this basically the end of our syllabus for this semester.